Lord, the parties have come to agreement about times, and this has been encapsulated in a draft order. The matter will be postponed to the 1st of November for hearing of the two applications contemporaneously and for hearing also of the intervention applications. And then the order also sets out times for filing of papers, and of course then also includes the fact that the report will not be released to the public, and the report will be preserved and kept in safekeeping. And last but not least, costs are reserved. I would move, my Lord, that an order be granted in these terms.
Just before you proceed, the date, the 1st of November, is now another date. The debate which we had concentrated on the date for next week. So the position now is, because the date is different, it's later during the year, I will have to confirm with the Deputy Judge President whether this date fits in properly in the administration of this court with regard to the availability of a courtroom and the availability of a judge to hear the application.
Yes, indeed, Lord. I may point out that the availability also of the respondent, her personal availability was an issue, and that had to be taken account of because she has duties towards the Parliament as well, and that this date has regard to those duties.
So can I then accept, or can I then convey to the Deputy Judge President that this is a date suitable to all parties concerned?
Indeed. It is. It has been agreed by everybody. It is, I can perhaps mention the intention to write a joint letter to the Deputy Judge President asking him to possibly make a special allocation because of the number of parties involved.
Now, finally, let me just make sure this draft order also now includes the application which has been set down for next week, Tuesday.
Yes.
Can I accept that the applicant and all the respondent, or are there more than one respondents in that application?
No, there's just one respondent, the public protector.
You represent the president?
Yes, I'm the applicant in that matter.
Yes. And in that application, is there only one respondent or two?
The two parties before the court in that application, the president and the public protector are both present and are parties to this draft order.
And there is no problem with regard to the public protector who presently occupies that office, as opposed to the one that will succeed her after the end of term.
When Madonsela spoke about parliamentary duties on Monday, that's the new public protector.
Yes.
So this has been clear, and we've got an instruction from the Office of the Public Protector in regard to this work.
And, my Lord, I've also been asked to mention by my learned friend, Ms. Platt, that this order be placed in the file of case number 79808 of 16. That is her application, so that there's no misunderstanding about it.
So what I now suggest should be done is I will take another adjournment. I will contact the Deputy Judge President before I make this an order to discuss this date with him. I then also suggest that you do not leave the court now permanently to return to your chambers, for in case there is a problem with this date, that everybody presently in court will still be available to discuss any alternatives. I don't say there will be a problem, but I have to approach the Judge President.
Indeed, we're indebted to you.
Court will take a short adjournment.
adjournment there from the North Gauteng High Court. So what we do know is that the report into state capture will not be released today. And as the judge was indicating there, the parties, it seems, have agreed that the matter will be postponed until the 1st of November and the report will be preserved. However, he is just going back into chambers as he needs to confirm this with the Deputy Judge President as that date is set for late in the year. So he's asked counsel to stay behind in case there is a problem. He says there shouldn't be a problem, but it seems that that issue of the interdict will be moved to the 1st of November and not to next Tuesday. And this order includes President Zuma's application, which will also be heard on the same day, the 1st of November. We'll have more analysis on this and exactly what came out of proceedings there earlier. Aldrin St. Pierre is there, so we'll try and get him for you to give us something of what came out of that. In the meantime, as the public protector, Thuli Madonsela, of course, winds up her term of office, political parties have been expressing their views about her work as well as other current issues. SABC News spoke earlier to ANC spokesperson Zizi Kodwa about her legacy.
There will be cases naturally because of people's location in society. For example, if you are a minister, if you are a president, such case where it involves the oath of office, maladministration, corruption, naturally, not because they will be isolated. But I think the good thing about outgoing public protector is that she always acted within the law and the constitution and defended the act of her office. And I think the incoming will also fill the big shoes, that she must act without fear, without prejudice, without favor, but also she must defend the act, a public protector act, but also she must act within the law and the constitution. And it's very important, so that you must act like a court. You don't consider public statements which are made outside. You act on the basis, law courts, for example, they operate on the basis of a principle of all the adjournment partem, that you listen both sides and objectively of the material evidence presented before you take a decision. And I think she will always be remembered, will always remember her for having stood her ground, even on such high-profile cases.
Yes.
I mean, we're not talking about Prasa, we're not talking about many other cases. She stood her ground, but using the law.
She's standing her ground up until her last day. She's supposed to leave the office today, but she's also supposed to release a report on state capture. It's in court today. Your thoughts on that, and why is there perhaps a push from the presidency to stop this report from coming out?
You will recall it's us, the ANC, who came up with a debate in the country about corporate state capture. It was early in January, after our Lekgotla, responding to a number of allegations that there were corporates, big corporates, were influencing whether it's adjudication of tenders or influencing some of our cadres who are in senior positions to favor them in terms of the work in government. And then we also, having said that in January, we created an avenue because we couldn't respond to public statements that were made and allegations. We created an avenue where we could get evidence and act in that evidence. But unfortunately, not all our cadres, all those who implicated public officials, used that opportunity. Two reasons. Not because they did not trust the process. Firstly was that they wanted what is called protection. Two was the issue of confidentiality. And some of them suggested that perhaps we must use what is called law enforcement agencies and state agencies. That's why many of them, they would have gone to the public protector. And as the ANC, we're looking forward to that report because we're looking for evidence of that report. Because any allegation of corporate state capture of a democratic government, of a democratic state, is a threat to the very nature and the character of a democratic state, but also to the character of our revolutionary movement. The ANC itself is a threat, that some of your cadres are captured. So we're looking for evidence, not something anecdotal. We hope that that report will point us to the African National Congress, but it's something that we've got to make sure that it's the African National Congress we guard against. When people elect us, they actually bestow their confidence on us. Hence, we deploy our cadres in some positions. If now it is discovered through material evidence that our cadres have been captured by this and that wealthy family, then is an issue that the ANC can just close and dig its head in the sand.
Mr. Kodwa, you touched on the public protector looking at cases that nobody would even take or notice of, and there is a case today that you've mentioned. But now, one of the cases, or that is going to continue, is the state capture process, and the new protector is stepping in. Now, what is your message as the ANC to the new public protector coming in terms of these particular cases that's sitting on a desk and moving forward?
The same as we said when the outgoing public protector was appointed. Like I say, her critics was that, she's from obscurity, she's a Zumaleki at the time.
Yes.
She's the President Zumaleki, she will listen to Lutuli House. Now history is a judge.
Yeah.
And I think the incoming must not feel under pressure because there's a possibility that she may act irrational and unlawful to please certain section. I like the advice of the outgoing to the incoming that always bring your team, act within the law and the act and the constitution. You won't make any mistake. And I think there will be a lot of pressure given some of the political noise already that she must take only high-profile cases. I like the example of the case I just mentioned from Mpumalanga. These are the kinds of people who don't get any attention because they don't have any high profile. These are the kind of cases sometimes I would like the incoming to focus, to make sure that she continues to restore the dignity of the Office of the Public Protector.
Arrangement and we prepared a draft order. I confirm that draft.
Do you have it in duplicate? Yes, there's only one problem. I'm not allowed to postpone one urgent application to another date in another court unless there are special circumstances authorizing me to do so. That is what I've explained to you earlier on. You will have to remove it from the roll. Once the matter is ripe for hearing, it's your choice to set it down in terms of the practice directive. I can't postpone it for you. You will have to set it down.
All the difficulties at the moment, the plant is not functional, there's no income, there's no work because of the spoliated goods needed for mining activities.
That I understand. I'm talking not about the merits. I'm talking about the procedure. Once you have received the last set of affidavits, you can set the matter down for hearing in the urgent court. What prevents you to do so?
But the matter is already urgent, and the Lordship has already given an order on Wednesday. And with all due respect, these are very special circumstances.
It isn't. You have an interim order protecting the integrity of the parties concerned. And in terms of the practice directive, once these papers have been filed, you then, not you, your attorney, sets it down for hearing.
In terms of the practice.
It is just as simple as that. You understand?
Yes.
Otherwise, if there are no, and it is not only exceptional, it is exceptional special circumstances. Like in the matter before yours this morning, you have heard the circumstances in that application. That is why I was able to invite the parties to do what I suggested, and I said to them, that particular date I first have to go and discuss with the Deputy Judge President. That is how serious it is. Now you want me to just postpone a matter to another date. I can't do it. You understand?
Yeah, because we were supposed to argue the matter today because of the urgency.
Yes. You can't. Let's not traverse that path again, because the matter is not right for you. So I'm going to delete that paragraph.
Paragraph 1.
Paragraph 1. And the deletion of this paragraph clearly means that if your attorney, acting for the applicants who are dominus litis, if he does not set the matter down, if he chooses to do it in the urgent court, in terms of the practice manual, this matter will not be on the roll. Do you follow? Yes, in this matter, which is case number 79839 of 2016 between Central Bridge Trading and another versus Rondebolt Colliery, the draft as amended, and which I have marked X, is made an order of court.
As it is.
Right, live proceedings are there from the North Gauteng High Court, still just deliberating on the date to hear that interdict against the release of the Public Protector's report. In this matter, case number 78423/2016, application of Mpaye, the draft which I've marked X is made in order of court. Yes. Any other applications?
Mr. De Tooy, perhaps I should also convey to you and all other counsel that the Deputy Judge President is presently sitting in court. I expect him to become available shortly before 1. I've requested the Secretary to notify me immediately if he becomes available earlier. So please bear with me. As soon as I've spoken to him, I will be able to finalize the draft.
I'm sorry, Malone. Just a suggestion maybe to assist the court. Two proposals, Malone. One could be a date subject to the DJP. The second one, Malone, is just to bring to the attention of the court that the parties deliberately chose a Tuesday, the 1st, so that the matter would, if there was a problem, be in the ordinary urgent court. So I just wanted to bring those to the Lordship's attention in case maybe there's a further problem with finding the DGP.
Yes, I know the date is important because it suits everybody concerned. But I don't think it will be wise to now make it an order subject to his approval. What if he does not approve it? Then there will be a big problem to get.
Then it comes to the ordinary road. I appreciate that.
So please, you will have to be with it.
That's correct.
I might just make a suggestion. I haven't had a chance to discuss it in my own defense. There's one other option, and this is, instead of putting in the date that we put it on a date to be agreed upon between the parties and determine what happens to the Deputy Judge President or working along that line. Because special allocations are fairly often dealt with the Deputy Judge President.
Yes, but then I am passing the buck to him to ascertain with everybody concerned a suitable date. I don't want to burden him with that problem. And you will have to wait another 40 minutes perhaps, and that's no problem for today.
Thank you.
Jeffrey. Kappa.
I can leave.
Yeah. Just give your phone number to the clerk.
Well done and thank you very much.